Good morning, friends. Today I am going to discuss a very important judgment and a recent judgment which was pronounced by the Honorable Supreme Court of India on 23rd of August 2024. This judgment has once again highlighted the importance of understanding the difference between the offenses related to the criminal breach of trust versus the offenses related to the cheating. The Honorable Supreme Court has come down heavily on the police, on the lower subordinate courts, on why, even after the period of 162 years since the IPC was enacted, still the courts or the police officers are not able to distinguish clearly the difference between the criminal breach of trust offense and the cheating offense. So in this video, I will first discuss the facts of the case in this judgment. Then we will discuss how the Supreme Court has once again, highlighted the importance of the scope of inquiry under the 202 of the CRPC. Then Supreme Court, in a very detailed way, has highlighted the difference between the criminal breach of trust versus the cheating. Supreme Court also addressed vicarious liability in the cheating offense versus the criminal breach of trust offense. And once again, Supreme Court reaffirmed the rule of law in relation to the cognizance on a private complaint. And finally, we will discuss what are the various conclusions made by the Honorable Supreme Court in this judgment. So let us start first with the facts of the case. So in this case, the three petitioners P1, P2 and P3 has approached the Honorable Supreme Court and invoked the appellate jurisdiction of the Honorable Supreme Court. They filed the criminal SLP, and to understand better, we need to go back in the timeline. If we see that on 27th of August 2021, a complainant has approached the additional chief judicial magistrate and filed a private complaint against P1, P2 and P3. In response to that complaint, the additional CGM has issued an inquiry under the 202 CRPC. In this judgment, the Honorable Supreme Court has also highlighted that what is the scope of inquiry under the 202 CRPC. We will discuss very briefly on that aspect. Now, after the inquiry, after going through the complaint petition and the evidence which were led by the complainant under the Section 202 inquiry CRPC, the summons were issued to the P1, P2, and P3. Obviously, after receiving summons in a criminal complaint case, the petitioners P1, P2, P3, they first approached the Honorable Allahabad High Court and sought quashing and set aside the summoning order issued by the additional CGM. However, on 3rd of April 2024, the Allahabad High Court declined to quash the summoning order, and that is why they have approached the Honorable Supreme Court and sought relief against the order of the Allahabad High Court. See, to understand the essence of this judgment, we need to get a bit deeper into the complaint. What actually were the content or the averments in the complaint were. If you look at this thing in the complaint, the original complainant invoked three sections of offenses. One is 406, that is the criminal breach of trust, 420 cheating, and the 120B, that is the conspiracy. To support the allegations and invoking the offenses under section 406, 420, and 120B, the overall matter was in this way. The complainant was supplying horse feed, barley, and oats to the P1, that is the Daily Race Club Limited firm. Okay, so everything was going well until 1995. And then the P1, that is the petition number one Delhi Race Club, they directed to the complainant that okay, from now onwards, you raise the bill to our second association, which is the Delhi Horse Trainers Association. If you look at this, okay, whatever you may continue to supply the material to us, but the bill will be cleared by this Daily Horse Trainers Association only. Now, since 1995 till 2017, everything was going well. Nothing was, no dispute was among the petitioner and the respondents. However, on the 2017, there is a dispute coming up, and in the dispute, the complainant alleged that 9,11,434 rupees were not cleared by the association number B. The complaint disclosed that various multiple visits were made by the complainant at the association level. They met with the secretaries, they met with the presidents of both the association, that is the petitioner number one association, which is a company in fact, and there is another association which is a daily horse trainers association. However, nothing happened, and that's where the complainant has now invoked the allegations in relation to the offenses related to 406, 420, and 120b. Now, if we overall look at the allegations disclosed in the complaint, the primary issues that in the year 2017, my 9 lakh 11,000 rupees were not released by the association number B. Nothing relation in relation to the petitioner number 1, petitioner number 2, petitioner number 3. Then in the year 2020, a legal notice was served by the complainant to the associations, both the petition number 1 also and the association number B also. After almost a time of 1 year, the complainant has approached the police station to start the process of filing a police complaint against the petitioners as well as other accused persons under the various sections. And as we have discussed that on 27th of August, the private complaint was filed against the additional CGM, who, after going through the inquiry proceedings under the 202 CRPC, the learned magistrate has issued the process for the offense punishable under section 406 of the IPC. So, in a nutshell, the complainant raised allegations of criminal breach of trust and cheating and conspiracy in the private complaint. But after the inquiry proceeding, magistrate took cognizance of only for the offense under the criminal breach of trust against the accused persons and issued the summons against these accused persons. So, if we conclude the facts of the case at the trial court level, the learned magistrate issued the summoning order for the offences under section 406 of IPC against six accused persons. Out of these six, three approached the Allahabad High Court. So let us discuss very briefly whether the Allahabad High Court find any infirmity in the order issued by the learned magistrate or not. So the Allahabad High Court held that there is no legal infirmity in the impugned order. So that is why there is no need for exercising their inherent powers as conferred under the section 482 of the CRPC. Hence, their petition under the 482 CRPC was dismissed, and no relief was given to these three petitioners. So, when this matter was ultimately heard by the Honorable Supreme Court, very critical observations were made by the Honorable Supreme Court. Against the Honorable High Court order, the Apex Court held that, the impugned order passed by the High Court is a fine specimen of total non application of mind. And overall, the Supreme Court held that even if the entire case of the complainant is accepted as true, not even a single offense can be made out. The key observation made by the Honorable Supreme Court with regard to the facts of the complaint were this: the complainant were supplying goods to the petitioner or the sister concern association of the petitioner. Since the goods were already sold by the complainant to the petitioner or the another association, the section 406 is now completely out of the picture. The matter is primarily plain and simple in the terms of civil matter. I have supplied the goods, you have not made the payments to me, so the matter must have gone to the civil jurisdiction for recovery of money. However, the complainant has chosen to set the criminal law in motion and filed a private complaint against the accused person. The Supreme Court has held that even if you consider all the facts mentioned in the complaint as true facts, even then you cannot make out any offense of cheating against the accused persons mentioned in the complaint. So, while arriving at these findings, the Supreme Court went into very detailed manner and highlights the importance of finding a very fine line difference between the criminal breach of trust versus the cheating. In both the cases, the intention to fraud or the dishonest intention must be present. If it is not there, then you cannot make out a case for criminal breach of trust or a case of cheating altogether. Whereas the key difference between the criminal breach of trust versus the cheating is that in the cheating, this intention has to be proved that the intention exists from the beginning of the transaction itself. In simple words, if I say, take an example that I made a contract with the builder and paid some money. Now, if the builder has induced me to pay him the money by giving me fake promises that the land is owned by the builder, uh, he has all the approvals from the appropriate authorities and he can build the society in that particular area. Now, if everything was not available to the builder, he was not having NOC, so that means that it has the intention from the beginning to cheat me. So that is where the offense of cheating will come into picture. But whereas on the other side, if I made a contract with the builder and builder has all the approvals with himself and I paid the money to him, subsequently during let's say after 2 years of the development work, the builder resold my unit to someone else. So that is where the offense of criminal breach of trust will come into the picture. Thus, we need to understand that every breach of trust cannot be a criminal breach of trust. Okay, unless and until you give an evidence of manipulating acts of fraudulent misappropriation in your complaint itself. If such allegations are not there, then the learned magistrates is not bound to take any action and to invoke the section 406 of the IPC based on your complaint. Another very interesting and important aspect which was highlighted by the Honorable Supreme Court in this judgment was that what is the role of the magistrates at the time of summoning the accused for an offense, either any kind of offense. The Honorable Supreme Court held that the magistrate cannot and should not act as merely a post office for the complainant, and whatever allegations the complainant has put up and has sought uh, prayer to invoke XYZ sections of the IPC, the magistrate cannot simply invoke those sections without carefully going through either the oral evidence or through the written evidence as filed by the complainant. And very interestingly, the Supreme Court has held that the best example of the application of mind is that you demonstrate it by disclosing of your mind on the satisfaction that you are satisfied that okay, because of XYZ reasons, because of the XYZ facts mentioned in the complaint, you are satisfied that A, Section B, Section C of the IPC needs to be invoked, and that is why the accused needs to be summoned. The Honorable Supreme Court also highlighted a very another important aspect. For example, we all advocates, approach the learned magistrate under Section 156(3), and if the magistrate is not satisfied with the allegations, he may generally sought an inquiry from the police, and then the police file its a report. Only then the magistrate will consider whether to take an action on the basis of police report or not. Whereas in the private complaint, the learned magistrate needs to be more careful, because in the 156(3), there is a another body which has went into the investigation, that is the police, and on the basis of the police report only the magistrate can take the cognizance. Whereas in the private complaint, if the magistrate is, without any application of mind, merely on the basis of allegations made in the complaint, take cognizance and issue the process for summoning the accused under the offenses as mentioned in the complaint, then the magistrate, then that particular order of the magistrate, summoning order of that magistrate, is liable to be set aside or to be quashed. The Honorable Supreme Court in this judgment very explicitly pointed out on the question of vicarious liability of the office bearers in the offenses related to criminal breach of trust or of the cheating. The Honorable Supreme Court very categorically disclosed in the judgment that our IPC or the statutes are completely silent on attaching vicarious liability on the part of the office bearers. And this complaint is absolutely silent on the roles or on the allegations against the office bearers of the company in relation to the offenses of cheating or the criminal breach of trust. Hence, the Supreme Court held that it is the obligatory, it is mandatory on the part of the complainant to make, to disclose the allegations against the persons, so that the appropriate provisions of, let's say, criminal breach of trust or of the offense of cheating can be invoked against these accused persons. The provisions of criminal breach of trust or the provisions of cheating cannot be invoked against the office bearers of the company, citing the vicarious liability of these office bearers. So finally, in the conclusion section of the this judgment, the Honorable Supreme Court firstly, disclosed that it is very much unfortunate that even after 162 years of the IPC, the stakeholders are not able to understand the fine distinctions between the offense of criminal breach of trust and the offense of cheating. This is the first thing. Second important thing which the Honorable Supreme Court has stressed upon is that the learned magistrates, in case of the private complaint, must carefully apply its mind to ascertain whether the allegations as stated, genuinely constitute these specific offenses as alleged by the complainant or not. Yeah, the magistrate must, disclose its mind on the satisfaction of this criteria. And thirdly, if it is within the jurisdiction of the police at the time of registration of the FIR, the police also must go through all the material in hand very carefully, and only then take a call that, the criminal breach of trust has happened or the offense of cheating has happened. The Honorable Supreme Court has held that it is high time the police officers across the country must be imparted proper training of law, so that they can understand the fine distinction between both the offenses. The Supreme Court categorically stated that both the offenses are independent and distinct. They are not twins to each other, that they cannot survive without each other. So if it is magistrate or if the police officer, they must be very carefully go through the documents, go through the evidence in hand, and accordingly invoke the appropriate section of these offenses. I hope this video would have helped you to understand the judgment and the fine distinction between the criminal breach of trust and the offense of cheating as per this judgment. And I will keep on updating new videos with relations to understand how the Supreme Court has laid down laws for us. Stay tuned to this channel, and you may like, subscribe, and share this video to your friends or the colleagues who wish to understand the fine distinction between the offense of criminal breach of trust and the offense of the cheating. And I will try to upload new videos to understand more about Indian laws and Indian judgments in various fields of law. Till then, thank you so much for going through this video. Stay tuned to this channel. Jai Hind.